All right, welcome back for module 10, and this is the AI supply chain governance module. Your AI vendor's AI vendor. Okay, so let's go to the scenario. 2 firms, 1 final gap. So, the first 6 modules, the scenario firm was Halstead Co. It has 90 fee earners, so that's paralegals, solicitors, senior solicitors, etc. The regional practice using commercially hosted AI tools. The final module, which is module 10, introduces a second scenario firm, and that is Thornbury Legal Ltd. Now, they are a mid-sized commercial firm that has taken a different route. So, they are operating a self-hosted contract analysis model on its own infrastructure. So, in this module, I'm going to show you how to cover the gap for both scenario firms. One firm, Halstead Co., is using commercial AI tools, and I've included Thornbury Legal Ltd to demonstrate how to close this gap when you're self-hosting an AI model. Now, does self-hosted equal self-governed? So operating an AI model on your own infrastructure does not eliminate the supply chain governance obligations under ISO 42001 clause 8.4. It changes its form. When an API's customer's governance burden falls primarily on the vendor's assessment and contractual controls, a self-hosted operator's burden includes foundation model license compliance, inference infrastructure security, fine-tuning data provenance, update pipeline governance, and operational resilience planning. Thornbury Legal Ltd has none of these documented. The self-hosted arrangement that appears to give the firm maximum control, in fact, exposes it to the maximum number of ungoverned supply chain risks. Now, for Halstead Co., using a commercially hosted API and SaaS tools, the supply chain gap is narrower, but still present. Each vendor is a node in a supply chain that the firm has assessed at the product level, but not at the component level. So OpenAI's AI uses Microsoft Azure infrastructure. Microsoft 365 Copilot uses OpenAI's models. Now, when it comes to Leap AI, it uses third-party inference components. None of these sub-processor relationships are documented in the firm's governance framework. So when it comes to ISO 42001 clause 8.4, it requires both firms to close this gap using the Reg AI Management System supply chain document, which is a supply chain register. So let's take a deeper look into clause 8.4 and see what it actually requires. So clause 8.4 scales with the complexity of the supply chain arrangement. 3 configurations arise in law firm AI deployments, each with distinct governance requirements. The clause creates an obligation and applies to every AI system in the register, regardless of how it's procured. So in plain English, clause 8.4 obligates the firm to govern how its AI systems are sourced, not just what they do. A hosted model carries more governance burden than a commercially hosted one because the self-hosted operator becomes responsible for layers the API customer delegates to the vendor. This is not a punishment for sophistication. It is just a proportionate response to the fact that the self-hosted operator is in fact making more decisions with less vendor support. So let's put the 2 law firms in this scenario side by side and look at the actual supply chain mapping. Okay, so we've got Halstead Co. and then you've got Thornbury Legal. So what you see here, so you got layer 1, which is the product, so the client-facing product, so to speak. Layer 2 is the infrastructure, and layer 3 is the foundation model. So if I was to let's take this one as an example. So Halstead Co., the product that they're using is Microsoft 365 Copilot, and that's in Word and Outlook. Now, the infrastructure that the Copilot product is on is Microsoft in the EU region. And then when it comes to layer 3, the foundation model is open. So you have the product, the infrastructure, and the actual foundation model. If we look at Thornbury Legal, Their AI tool is self-hosted. So for the product, they have legal AI vendor. Now the vendor AI governance is unassessed. When it comes to the infrastructure, so it's on Thornbury's own servers, there's no updated governance. And then finally, when it comes to layer 3, the foundation model is a third-party model. So the base model license is unreviewed. So the fine-tuning provenance is unknown. Now, red means that immediate action needs to be taken. Those sections that's in green, they're in green because the tenant boundary has been confirmed. And then you have blue, which refers to the Halstead Cole using the Open API model or product per se. They're using its standard commercial terms and agreement. Now, clause 8.3, which we covered in module 7, and we produced the AI management system data governance document. That document addresses what data goes into AI systems and what legal basis. Clause 8.4, which is the module that we're covering now, which produces the AI management system supply chain document. This document addresses the governance of the AI component themselves, their provenance, performance standards, and failure modes. The two are complementary. So the AI management system data governance document records the data dimension, and the AI management system supply chain document records the component dimension. A firm that has one without the other has incomplete supply chain governance under the standard. Okay, so what goes in each part of this AI management system supply chain document? All right, so there's 3 layers. Vendor AI governance assessment. Now, for each AI vendor in the AI management system document, the vendor's published AI governance framework, which is the ISO 42001 alignment, responsible AI commitments, model update process, bias assessment approach. That document, the contractual AI governance terms in the data processing agreement or service agreement. Also, the vendor's incident response obligations and whether the vendor has undergone independent AI governance assessments or certification. This is a primary desk research exercise for major vendors. OpenAI, Microsoft, and Leap all publish significant information to complete layer 1. For specialist legal AI vendors, like what Thornbury is actually using, a formal vendor questionnaire is required. So for audit evidence, the assessment record for each vendor dated with source references to vendor documentation. So that's needed for layer 1. Layer 2, which is the infrastructure and hosting layer, for each system, document the hosting jurisdiction, the infrastructure provider, whether that's Azure, AWS, the Google Cloud Platform, or your own servers, the data residency configuration, the security certifications held by the infrastructure provider, so that's the ISO 27001, SOC 2, etc., and the sub-processor relationship between the AI vendor and the infrastructure provider. For API developments, most of this is documented in the vendor's security white paper. For self-hosted deployments, the firm is the infrastructure provider and must document its own controls. So the evidence in layer 2 is the infrastructure certification register, the data residency confirmation, and the sub-processor mapping. Right, now we've got layer 3, so the foundation model and training data provenance. Now this document will have the foundation model or base model used, the model provider's terms of use, so this will be related to restrictions on fine-tuning, commercial use, and output use, the training data provenance, so what data sets were used, consent and copyright concerns, and for self-hosted fine-tuned models, the provenance of the fine-tuning data specifically. Now for Thornbury Legal, layer 3 requires a legal opinion on the fine-tuning data before the register entry can be marked as confirmed. This is the layer where most firms have the largest documentation gap and the layer where the regulatory exposure is at the highest. So the evidence needed to cover layer 3 is that the model license review, the training data provenance record, the fine-tuning data legal opinion. Okay, so let's just take a look at the Thornbury Legal and their self-hosted contract model. So Thornbury Legal Ltd operates a self-hosted contract analysis model deployed on its own infrastructure. The model was procured from a specialist legal AI vendor and fine-tuned on the firm's historical contracts. It is being used daily by the commercial team, and the firm believes it controls this system completely. However, it does not. And we're going to just take a look at why. So, the base model on which the fine-tuning was performed was itself trained by a third party. A foundation model provider who terms govern what the model may be used for, how it may be modified, and what update obligations apply. The inference layer running the model locally uses open source components with their own licensing and security obligations. The fine-tuning dataset included contracts from Thornbury's former clients. The firm did not obtain those clients' consent for those contracts to be used as AI training data. This is potentially both a breach of client confidentiality under the SRA's Principle 6 and a UK GDPR violation. Almost all commercial contracts contain, of course, personal data. So in this scenario, the vendor releases an update to the fine-tuning pipeline, let's say last quarter. Now, the firm, Thornbury, applied it without any governance review. The new pipeline produced better results in the vendor's tests, but included a model behavior change that Thornbury's risk register had not flagged and that its human oversight procedure did not catch. Now, the AI management system supply chain document forces this question into documented governance rather than leaving it as an legacy risk. Before layer 3 can be marked confirmed for the self-hosted model, Thornbury must, number 1, review the foundation model license in full. Number 2, obtain a written legal opinion on the fine-tuning dataset's client's data's implications. Number 3, conduct a DIA. Number 4, document the update pipeline governance. Now, until these are complete, the model should be classified as under review and its use restricted to non-client matters. Okay, so let's take a look at the 4 supply chain failures, or failure patterns rather. Now, the first one is support chain not mapped below layer 1. So the firm has assessed the primary AI vendor, which is OpenAI, Microsoft, Leap AI, but they have not mapped the infrastructure and foundation model layers beneath it. The sub-processor relationships, hosting jurisdictions, and model training provenance are unknown. This is the universal baseline failure for API and SaaS deployments. So when it comes to the audit findings, you've got the sub-processor relationships and infrastructure layer governance not documented for any registered AI system. So clause 8.4 obligations are partly addressed only at layer 1. Okay, the second failure pattern is no vendor AI governance has been assessed. So the firm has reviewed the vendor's data protection terms, but has not assessed the vendor's AI governance, how they handle model updates, what their incident response process is, how they manage model drift, and whether they conduct bias assessments. This information is publicly available for major vendors like OpenAI and Microsoft, but has not been reviewed or documented. So when it comes to the audit findings, vendor AI governance frameworks reviewed for data protection only, broader AI governance, so model updates, bias assessments, incidents response, and so on, is not reviewed or documented. The next gap relates to self-hosted. So self-hosted full supply chain burden is unaddressed. So for Thornbury Legal, the self-hosted arrangement creates obligations that API access does not. Foundation model license compliance, fine-tuning data provenance, and this is where the training contracts properly consented for AI use. Also, the inference infrastructure security and update pipeline governance. Now, none of these are documented. So the fine-tuning data sets use of former client contracts raise both an SRA confidentiality and UK GDPR questions that the firm has never formally addressed. So the audit finding is self-hosted AI system operates without documented foundation model license review, fine-tuning data provenance assessment, or update pipeline governance. Client data exposure potentially. And then the final gap is no supply chain incident response. So neither firm, neither Halstead Cole or Thornbury, neither firm has a defined response pathway for a supply chain AI incident. A vendor model's update that degrades performance, a foundation model provider that changes its terms to restrict legal use, or a security incident at the infrastructure layer that potentially exposes client data. The life cycle procedure includes trigger T8 for supply chain changes, but T8 can only fire if someone is monitoring the supply chain. So when it comes to the audit finding, there's no supply chain incident response procedure has been documented or defined. There's no quarterly monitoring of vendor terms and model updates. Nothing is documented for any registered system within both companies. So how do they fix this? Well, they'll fix this in 5 steps. So first you've got step 1 or layer 1. And layer 1 is document the vendor's published AI governance framework. So that's the ISO 42001 alignment, responsible AI commitments, model update process, and bias assessment approach. Also document the contractual AI governance terms in the data processing agreement or service agreement. Document the vendor's incident response obligations and whether the vendor has undergone independent AI governance assessment. Now, for major vendors, this is simply a desk research exercise. For specialist vendors, a formal questionnaire is required. Now, layer 2, for each system, you've got to record the hosting jurisdiction, infrastructure provider, for example, AWS, Azure, Google Cloud, or even your own servers. So you've got to record that information. You've got to record the data residency configuration, the security certifications held by the provider, whether that be ISO 27001, SOC 2, etc., and the sub-processor relationship between the AI vendor and the infrastructure provider. For self-hosted deployments, the firm documents its own controls. For layer 3, you need to record the foundation model use, the model's provider's terms of use, so that's the restrictions on fine-tuning, commercial use, and output use, and the training data provenance. For fine-tuned self-hosted models specifically, record the fine-tuning data provenance and the legal opinion confirming the data was lawfully available for AI training. Now, without this layer, the foundation model remains as ungoverned risk, regardless of how carefully the firm governs layer 1 and 2. Okay, now we got step 4, which is the supply chain monitoring. All right, so designate the IT lead as the supply chain monitor. And what they will do quarterly, they will check the vendor terms for material changes, check infrastructure provider certifications for lapses or changes. They will also check the foundation model provider announcements for license or policy changes. Any material change fires the trigger T8 in the lifecycle process document. Record each monitoring check in the supply chain monitoring log, which we're going to cover shortly and is part of the AI management system supply chain document. Then you've got step 5, which is the supply chain incidents response. Now, a supply chain incident is a vendor's security breach, a material vendor term change that affects lawfulness, a foundation model license change that restricts permitted use, or a supply chain component failure that affects AI system performance. The escalation path follows the lifecycle procedure, which is T8, under review, and then the AI governance lead makes a decision, but adds specific steps to vendor notification obligations and client notification assessment per Module 8's disclosure framework. So those are the 5 steps needed to fix this supply chain gap. Now, for Thornbury Legal, before the AI management system supply chain document part C can be marked as confirmed for the self-hosted model, Thornbury Legal must 1. Obtain and review the foundation model license in full. 2. Obtain a written legal opinion on whether the fine-tuning data's use constitutes processing of client personal data and whether consent or another lawful basis was available. 3. Conduct a DPIA for the fine-tuning data processing. 4. Review and document the update pipeline governance. Until these are actually complete, the self-hosted model should be classified as under review in the AI management system documentation for it, and its use restricted to non-client matters. Okay, so what firms cannot verify and how to document it. So for clause 8.4, it requires the firm to determine and document its supply chain governance. Now, it does not require the firm to independently verify every vendor claim. So where a vendor makes a representation about model training data or bias assessment or security controls that the firm cannot independently verify. The register documents the representation, its source, so public documentation, contractual terms, or vendor questionnaire responses, and the firm's reliance on that representation. An unverifiable claim is still a governance record. An undocumented claim is a governance gap. So, like in all the other previous modules, I have a template here, the AI supply chain register. And in these sections, you've got the section 1, so the 3-layer supply chain register consolidated view. So consolidated view being it's got to include the local AI as well as the commercial AI tools. So you've got the vendor, the provider for each layer. So here, as you can see here, and note the document ID. So you can see that sys or what is referring to the same AI tool, which in this case is the ChatGPT 4. So for that system, ChatGPT 4.0, there's 3 layers, as we've already discussed. Okay, so the provider for layer 1, OpenAI, the provider for layer 2, which is the infrastructure, that's Azure, and then layer 3, which is the actual foundation model, and that's the OpenAI's ChatGPT. All right, so you've got the provider, you've got the layer, you've got the governance assessment that's needed, and then you put in the controls that is actually in place. The other sections is the status and an actual date when the next review will take place. We've got section 2, which is relating to the Thornbury Legal Limited example of a self-hosted model. And again, for each tool, I should say, so in this case it's the Leap AI. For each tool, again, it follows the same pattern. What needs to be documented is the governance for the product layer, so that's layer 1, the infrastructure layer, that's layer 2, and the foundation model layer, which is layer 3. Governance assessment, the controls that's required is status and its deadlines in terms of target date. Okay. Then we've got the section 3. So this is the vendor AI governance questionnaire. This questionnaire is what you want the actual AI vendor to answer. So in here, I've got 8 questions and I split the responses up between Halstead Cole in terms of their commercial tool and Thornbury Legal in terms of their local. And the purpose of this, what you can look at is the questions that is asked and then the responses that they've got from the AI vendors themselves to understand the type of information that you will require back. Then section 4 is the supply chain monitoring log. And this is performed by generally the IT lead or the AI governance lead in that matter. You've got the system, the check type, the results of the finding, and then what actions needed to be taken place. Section 5 is the supply chain incident response procedure. So it got the steps, what actions to take, and the timescales with regards to whether it's immediate, 5 working days, 10 working days, and so on. Gap 6, Section 6 is the AI management system completion record. Now, this is for all 9 gaps. So everything we've covered in the previous 9 modules. So as you can see, right now this module 10, is closing gap 9, which is the AI supply chain register. But what we've already covered is for gap 1 was the AI policy. Gap 2 was the AI governance roles, responsibilities, and authorities. Gap 3, the AI system register and prompt version log. Gap 4 was the AI risk and impact register. Gap 5 was the AI system lifecycle procedure. Gap 6 was the AI data governance register. Gap 7, the AI client disclosure template pack. Gap 8, the human in the loop oversight procedure. And now gap 9, which is the AI supply chain register, which we've just covered here in module 10. Okay, so this, like all the other templates, is available to download in the link below. Also, you could get access to the actual module, wherein you can test yourself with the different quiz questions here. And I've put in here, how many? 3. So three questions for you. I've put in there a summary of, again, the documents and the gaps that were closed. So we've got the policy, I'm not going to go through it all again, but AI policy, the AI governance, and so forth, and showed that we've completed it. And here we're at the final module. Okay. And then to wrap this all up, I provided you with the checklist like all the other modules, so that you've got an understanding of the scenario, understanding of clause 8.4, understanding of the failure modes and process, and then an overall understanding of the whole series as a whole under the legal track. Okay, so that wraps up this 10 module series on how to close 9 gaps that is needed for firms before they roll out any AI tool